Meghan Markle, you'll be familiar with what has happened here. She's claimed a victory over moral exploitation after winning that High Court privacy case against the Mail on Sunday, after the judge ruled that the publication of extracts of a private letter she sent to her father was manifestly excessive and unlawful. She sued Associated Newspapers for breach of privacy and copyright relating to the publication of 5 articles. 2 appeared on Mail Online and 3 in the Mail on Sunday. This is February 2019. However, it's been described by media experts as a bad day for press freedom, acknowledging that the case was widely expected to go to trial so that evidence could be tested. Let's speak to Ian Bloom, media lawyer. Ian, good afternoon to you. So, I mean, it's always going to be tricky, isn't it? It's tricky when you deal with high-profile people. I understand, and you can clarify this, that it gets even trickier when it comes to sort of private letters and things like that. This was never going to be necessarily straightforward.
Good afternoon, Ian. I'm more interested, actually, in you sharing grass with Nigel Farage. But
yeah, there's a headline.
For another time. But back to matters in hand. Let's start like this, shall we? The letter that she wrote in about August 2018 to her dad was clearly a private and personal letter. The Mail on Sunday got hold of it, and they knew, because they know this stuff anyway, just as you do, that the copyright in that letter belonged to Meghan Markle. The physical letter, the actual piece of paper, belonged to her dad.
Yeah.
But her dad had no right to authorize anybody to quote from it unless Meghan herself assigns or sells the copyright in that letter. She can decide whether or not any part of it is published.
Yeah.
And clearly she didn't give that permission. The Mail took a calculated risk. They decided that it was worth the possible case for breach of copyright and breach of privacy to publish, because of course they got worldwide headlines, they got lots of clicks, because a couple of these excerpts were on the Mail Online, and they went ahead. And they balanced that possible legal claim against them with the enhanced revenues from the clicks and from the sales of the paper. And 2 years on, which is a surprisingly long time for a summary judgment application, as you will know, summary judgment means we don't have to go to trial. The defense is so hopeless it can't succeed. Let's cut the costs and just give the claimant judgment now. And that's what Lord Justice Warby, a hugely experienced media lawyer, decided. He actually acted for the Mail on Sunday when he was a barrister, so he had no particular axe to grind against them. Yeah. He simply applied the law of copyright and the law of privacy, as he has helped develop it and as he understands it, to the facts of this case.
And what's interesting is, as you rightly say, Ian, I'm not a lawyer, but I could have told the Mail Online that there was a copyright issue here, but for reasons I won't dwell on too much, I was just aware that it is your copy, it's your letter, it's therefore your copyright. Now, the Mail would have run this past every senior editor, manager, and one assumes a team of lawyers as well. And they would have been given the same answer, that yes, this would be a breach of copyright. As you say, they took a calculated risk. Now, I understand that risk. I mean, sure, they got all the clicks, and who knows what the revenue specifically was from that. The breach of privacy damages could be $300,000, we understand, but the award for infringement of copyright could exceed that. What's your professional opinion, Ian, on whether the venture from the Mail on Sunday's position is as to whether that journey was worth it?
My view is that it wasn't worth it, but this is quite unbelievable, Ian. Someone's coming to my front door with a parcel, but I'm going to ignore them. I can just see them out the window.
Could be something good there. I mean, there might be something.
It might be a lifetime subscription to the Mail on Sunday. You never know.
Yeah, well, it could be. That comes in parcels. So
no, what I think, about 10 years ago, I co-wrote a book on copyright. We were struggling then to find cases that were good enough to comment on in our book for the level of damages for breach of copyright, because it isn't usually, these cases are not common. They're not normal. And the cases are settled normally. You pay a little bit of damages.
Yeah.
In extreme cases, you pulp the book or whatever, but they're not common. And the damages for breach of copyright are not that high. The damages now for breach of privacy are much, much greater. And whilst 300,000 is a speculative figure,
Sure.
Who can guess what it might be? The assessment of damages will be a terribly difficult calculation.
Yeah, I guess.
But
So.
I'm not sure that this is all about a monetary award, because I suspect that Meghan, like Harry, will donate the monies to charity. This isn't about the money. The cost will be very considerable, but it's not about money.
Yeah, I was going to say, can public interest ever override laws in this respect? I'm thinking, when I was trying to imagine, any newspaper articles where there's been people printing or telling a story of a letter. For some reason, I've got it in my head, there must be someone who's published stories of a well-known prisoner, I don't know, Yorkshire Ripper or something, who wrote to somebody, and then a Sunday newspaper published those letters. Now, one would assume that even if you're on the inside in a prison cell, that's still your copyright. That's you don't in perpetuity surrender all of your rights in that respect. However, a newspaper might say, well, we are talking about a serial killer here, so it's in the public interest. What would happen in a legal dilemma like that? Would the copyright issue still stand?
Yeah, there's two issues, really. The first is it in the public interest to publish something that is essentially private? And there was no sufficient public interest in the Meghan case. It was a personal letter, a long telling off, I think the judge called it. Where you've got the Yorkshire Ripper writing a letter that's leaked to the press, the first issue is who on earth is going to act for him? How's he going to pay them? And what is the damage? What's the measure of damage? It'd be a frivolous claim. It wouldn't happen.
It wouldn't be reputational.
It wouldn't arise. There's no reputation there. Although reputation isn't the issue, it's a copyright claim, pure and simple.
Sure.
But if you start searching for examples, you can, the thing breaks down. If you focus on this case, here we had I think a pretty cynical decision by a paper in a long-running battle or became a long-running battle with Meghan and Harry to have a go at them.
Yeah.
And that's what they did.
But I guess, if it does, and you're right, I mean, this was a theme, it was a narrative, they were kind of on this on a fairly regular basis. But, if it turned out, Ian, that, the over there in the bean cruncher department at Mail HQ, they say, well, to be honest, we made about £1 million out of all of this, and our damages and everything's going to be 700,000, so we're quids in.
Yeah. They will probably be doing something like that, looking at the cost benefit analysis. What they're apparently doing, though all losing defendants say this, is we're considering the judgment carefully and we'll decide whether to appeal.
Yeah.
In 2 weeks' time, there's a further directions hearing. In 8 months' time, there's a full trial scheduled for what remains of the case.
Will that happen?
I'm not a betting man, but I'd put my last 50p on it settling, because I can't see why the paper would continue. It's suffered a defeat on copyright. It's suffered a defeat on privacy. It's got a tedious data protection claim against it. It's hard to see that there's any benefit to the paper in continuing, but I'm not the Mail on Sunday. I have clashed, when I was in practice, I've clashed with the Mail on Sunday over stories they wrote, but that's a while ago.
Interesting. Maybe we'll pursue that on another occasion. Ian, great to speak. Thank you. Ian Bloom, media lawyer, with us here on Talk Radio. It's fascinating. Lots of people I know that work in newspapers at the time when this case was first coming around said, the Mail will win this. They will win this because, the public interest element will be quite clear, etc. But I always thought, and it was only because I published a book a few years ago where we had to replicate people's letters in the book, that I was aware of this. It's not even a quirk. It's obvious when you think about it. But when you write the letter, you own the copyright to the letter. So it didn't really matter whether it was in the public interest, because I'm sure there was an interest to some members of the public. And it was, it's good tabloid fodder. Here's a woman who's married into the royal family, the actress who becomes an accidental royal. The whole story about it was mad. People say, well, why didn't they pick up on the Duchess of the other one, whatever her name is, Catherine? And cries of racism and all this. No, it was none of that. It was just that this was a darn good story. Everything about it was amazing for tabloids. And then they get the letters from the old man that she'd written to him, and they took that risk. But I knew when print journalists were saying to me, they could win this because of the public interest, and there's nothing odd about doing this. Very typical material and fodder for a tabloid newspaper. I always thought that the copyright thing would override all of that. And Ian Bloom has just completely confirmed that point. I think a lot of people would have perhaps been able to advise the Mail at the time at a much cheaper rate than the one they got. 03444991000.